So are we doing, there's public comment at 2 minutes, or are we going to do 3? We're doing 3. And yeah, I'm just going to mention, we're going to give public comment time during the agenda item, so they don't have to say something about everything off the bat. So puts it a little more in place to where it is. And they were always 3 minutes apart, so it just mattered which one you went with. All right, that's 6 o'clock by the 1 o'clock we have here. Welcome everybody. This is the August 23rd, 2021 Dalton Township Zoning Board of Appeals meeting. You see us look a little strange. You know, we went from nobody here to Zoom meetings to a full house. So we're keeping us okay. But if we forget to look up and see you out there, that's probably why. So, all right, we're going to start with roll call. I am here, Craig Manott. David? Here. Nola? Here. And Marvin? Present. Okay. Next is the approval of the agenda. One of the things we just wanted to make note for everybody, we've struggled trying to figure out how to put this in the agenda correctly. For those of you who are here wanting to make public comment, there's obviously a spot at the bottom for public comment. That's usually reserved for any public comment for a non-agenda item, so if there's anything else you wanted to bring to us, we're certainly going to have that opportunity. Otherwise, we're going to take time, and we think we have 3 minutes, so we're going to have time for each individual item for public comment. Typically what we do is we have the applicant present their application to the board. Then we'll have some time for public comment, if any neighbors or anybody else wants to make a comment. Then after that, we'll close public comment, and we, the board, will then begin to discuss that. And we may or may not still have some questions for the applicant, but typically that's the end of public comment for that individual agenda item. Hopefully everybody has an agenda and knows what order we're going into. I think there were some. What case? Stephen, am I correct? Yeah. There. If you don't have one, they'll be there as well. So that said, if everybody has a chance to review the agenda, the motion in support of approval of the agenda.
Make a motion to approve.
David? Support. All right. No. All right. All those in favor indicate by saying aye. 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 Any opposed? All right. Our agenda for the August 23rd meeting is approved. Next, we have the approval of minutes for the June 21st, 2021 meeting. If everybody has had a chance to review those. And if there are no additions or corrections noted by anybody, if somebody would like to move to approve those.
I'll move to approve those minutes as presented.
Thank you. Is there a second?
I'll second.
And David. All right. Any comments, questions regarding that motion? Otherwise, all those in favor indicate by saying aye.
Aye.
All those opposed? All right. The June 21st minutes also passed. All right. Next, we have a presentation by Jeffrey Martin, who's going to discuss the new enforcement process that I believe will then be helpful as we consider the third matter today. So, should we start time for you, or where?
It's gonna be a little while. So, which I appreciate you guys making time for me. I think this is the best venue to be presenting this information. On this specifically, it's a good question of why I am here. Normally, a township supervisor does not attend the Zoning Board of Appeals meetings, and I'm recording this just for documentation from Michigan State University because I'm doing a course through them in zoning. I did their Citizen Planner course. This is part of the Master Citizen Planner course, and I'll go through the full Zoning Administrator course as well, which Stephen will also be working on too. And I will leave immediately after I get done, so I'm not here for the rest of the Zoning Board of Appeals meeting. greater than just presenting for the certification through Michigan State University, which I'm working on obtaining as much of that information and knowledge as I can as I move forward in office here. This plays directly into, with due process and zoning, why I ended up running for office, because it started with me having a disagreement with the township over, to a large extent, due process. A farm that I liked, that I had been going to, which is also in the township, and I, of course, live in the township. They had the township pursue legal action against them. And I thought it was a violation of due process. And at that point, I have to decide to what extent you have a moral obligation to get involved. And I started out writing articles, obviously went all the way through me taking and holding office at this point. And so that's more of why I got involved, but the reason that I made that decision has to do a lot with my own study of history around these types of things. And for instance, this is based on a speech by Grover Cleveland, the Democratic president. It's called Good Citizenship. And in here it talks about a few different principles that I think are important. One of them stating that every citizen should be politician enough to bring himself within the true meaning of the term as one who concerns himself with the regulation or government of a nation or state for the preservation of its safety, peace, and prosperity. Another part states, it should teach toleration in all things, save dishonesty and infidelity to public trust. And another part, it should enjoin respect for the law as the quality that cements the fabric of organized society and makes possible a government by the people. So with these, if you put these together, you would say that if the public trust is violated, then every citizen should be politician enough to try to get the laws enacted in the way that they should be, or to go through the process of changing those laws for the betterment, which is what I am attempting to do. This book is The Power of the Powerless by Václav Havel, that led the Czechoslovakian Revolution against the communist government. Written in the 1970s, he was in prison for 3 years for writing this book. And he went through a process against the government that he disagreed with, and eventually won at a much higher level, of course. But in here it states, there is in essence only two ways to struggle for a free society. That is through legal means or through armed or unarmed revolt. He also states, it should be obvious at once how inappropriate the latter alternative is in the post-totalitarian world. It obviously ties more into his larger philosophy, but one that I happen to agree with, that we have certain means for making these types of corrections, and therefore we have a duty to carry those out. And the most important work for me doing this entire endeavor of attempting to take office and make the changes that I find are necessary is this little book, The Question of German Guilt by Karl Jaspers. He was an existentialist philosopher. He came up with how we classify mental diseases to this day. He invented the idea of the axial age in philosophy. His wife was a Jew. They lived through World War II. He was a professor at a university, was not allowed to work. They were essentially put on home arrest for the entire war, but they weren't killed. Afterwards, he almost immediately gave these talks at a university on to what extent different people in the society were guilty of what. And in here, he classifies 4 different types of guilt, which I think is interesting. One is criminal guilt, which we all know about and agree on to a large extent, I do believe. The next is political guilt, which is a little different. And he states everybody is co-responsible for the way he is governed. I don't know if that's always true, but I do believe in a representative republic that definitely is true, and therefore there ends up being a responsibility in everyone for them. The next, he states moral guilt. And I, who cannot act otherwise than as an individual, am morally responsible for all my deeds, including the execution of political and military orders. And his last article of guilt is metaphysical guilt. And in this one he states that there exists a solidarity among men as human beings that makes each co-responsible for every wrong and every injustice in the world, especially for crimes committed in his presence or with his knowledge. So that the closer it gets to us in time and space, the greater responsibility we have, which also echoes the statement of Václav Havel. Now, specifically to get into how corruption works, I believe there's a lot of times a lack of engagement and then also a lack of vigilance. And I really appreciate everyone coming because that is a decent amount of engagement, having people here. And with those things, you have a tendency towards self-selection, in that the only people that get authority in the society are the ones that try to get authority, which can be a major problem. And then the feedback mechanisms end up corrupted and distorted in a way that it's hard for the society to correct for it. Due process, specifically, is what we're going to talk about in zoning. Due process is relatively old, the idea that there should be a process that you go through. Our concept of due process comes originally from the Magna Carta in 1215. The first time that it's actually used stated in those words is the version of the Magna Carta passed in 1354, which states that no man of what state or condition he be shall be put out of his lands or tenements, nor taken, nor disinherited, nor put to death, without he be brought to answer by due process of law. So that is the first time it's used. So it's relatively old. Depends on what you consider old. And that was updated several times, obviously. The Magna Carta was passed a number of different times under different kings with different variations. In 1628, under Lord Coke, we have the Petition of Right, which is directly where several of our amendments and our 10 amendments come from, and he was later killed by the king. But those things were also updated in 1689 as part of the English Bill of Rights, and of course that leads to the 1789 to 1791, depending on whether you consider it passed by Congress or ratified by the states, the American Bill of Rights. And encoded in the Fifth Amendment, we have a due process clause, also in the 14th Amendment. There are different types of due process because American law and British law ended up diverging. American law kept a pretty good focus on due process. British law has moved away from that. But there is substantive due process. And substantive due process is basically what we mean when we say rights. It's just kind of a technical term for it. What we're really talking about here is procedural due process, that certain things need to occur in a certain order for things to happen to people. And at a minimum, it's usually recognized that the person has to be given notice, that there should be an opportunity to be heard, and that there should be a decision by a neutral decision maker, which is the Zoning Board of Appeals in this case. And the importance of due process, I think, is highlighted. There's an article that I wrote for the White Lake Beacon called Procedure and Substance. And in here I quote Winston Churchill when he's defining what civilization really is. And in here he says, it means a society based upon the opinion of civilians. It means that violence, the rule of warriors and despotic chiefs, the conditions of camps and warfare, of riot and tyranny give place to parliaments where laws are made, and independent courts of justice in which over long periods those laws are maintained, which is part of the process here today because the Zoning Board of Appeals is a quasi-judicial board. Zoning is relatively new in its modern form. It obviously goes back thousands of years. In ancient cities, you couldn't do certain things inside the city gates. So really, it's been around for thousands of years to that extent. But the modern version of what we call zoning really comes around in the United States in large cities. In 1908, Los Angeles enacted zoning. In 1916, New York City enacted zoning. Then the federal government, under their Commerce Board, ended up making a Zoning Enabling Act model for states to pass in the 1920s. There's a big zoning case in 1926 about that, of the Village of Euclid versus Ambler Realty Company. And in that, it moved all the way up to the Supreme Court. And the legality of zoning was upheld, specifically under the police power that the township holds. So in short, the court ruled that zoning ordinances, regulations, and laws must find a justification in some aspect of police power and is sorted for the public welfare. So it's been tried and it's been upheld, and now we're about a century into zoning, about 100 years into zoning. Specifically for this board, which I'm not talking about any of the specific things that are going to be happening here today because that's not my position, that's the position of the board on those. But the reason that we can bring things to the board is because there's an administrative appeals process. which is part of what we're enacting in the due process that we're doing. And so this is an article from Michigan State University, but it says that the ZBA is the only entity authorized to hear appeals on the administration and enforcement of the zoning ordinance at the local level. So there's nowhere else for it to go at this level. It has to go here. That's what this board is for. Also, a government official or body can appeal an administrative decision to the ZBA. So a citizen can obviously appeal something to the ZBA, but also we can take it upon ourselves as administrators and as part of the government body to appeal things to the ZBA, which is what this ordinance is about. When the ZBA does hear an appeal of an administrative decision, members must understand they are not issuing a new decision because it is a quasi-judicial review. So that would be the place of the planning commission, something like that, to change ordinances, which there are obviously things for. The ZBA has the authority to reverse or affirm in whole or in part or modify the administrative decision appealed. And they must include facts and reasons for the decision. So that is what the board is here for today. Now, if someone has their case presented here and then they decide to move beyond that, they can move into circuit court. And any decision made by ZBA is subject to review by the Circuit Court of Appeals. And it's the next stop for this quasi-judicial process, including the administration of zoning. So it can move up, and specifically what they're going to be looking at that next level would be if it complies with the Constitution and the laws of the state, if it is based upon proper procedure, if it is supported by competent material and substantial evidence on the record and represents the reasonable exercise of discretion granted by law to the Zoning Board of Appeals. So that's kind of the before and after of this step. Now specifically, I have here, and it's included in your packet near one of your enforcement items. But this is the resolution that we passed. And the reason it's in a resolution format instead of an ordinance format, and I talked this out with the lawyer, and I know I messaged some of you and talked to you about it, about how we should do this. There may be some kinks in here. It may not be the greatest process that I've come up with. I reviewed a bunch of materials and put this together. But we're, to a certain extent, a little bit on the cutting edge. This is a debated thing to what extent a township should have due process. I think it's extremely important for people's rights for the township to have due process, and not for me to arbitrarily be able to do whatever I want. I believe that's very dangerous. That's why I moved forward with this. But this, being in a resolution format, will allow us to work those out before we go through the process, through the zoning board, or through the planning commission, to make it an ordinance, and thus it'll be in the ordinances, but that's probably a 6-month process if everything goes well, and then it's more substantial, a lot more difficult to change. This reads, whereas an objective process of enforcement is necessary for consistent and just action by the township, whereas Dalton Township desires a consistent and just process of enforcement, whereas the laws, ordinances, and regulations that govern a society continually evolve in proportion to the beliefs and opinions of citizens, whereas the seeking of an ideal justice that balances liberties and obligations requires continual work and adjustment in pursuit of determining the expanse and limitation of both liberty rights and claim rights, now therefore be it resolved that a process of enforcement in Dalton Township is declared as follows. So you can tell that I wrote this. I wrote this from scratch, and it sounds a little bit like the beliefs I've previously presented here. The first provision is that a written complaint is received that may or may not indicate an ordinance violation. Now this, there's already been some debate on this, as there's going to be, as there is throughout society, about the necessity and importance of a written complaint versus something coming in as a verbal complaint. So that's one of those things that needs to be worked out, why it's a resolution, not an ordinance. Number 2, discovery is begun with an initial inspection. And this hopefully is occurring in the first week as well. I included a time frame in here. Number 3, if a violation is determined to exist, a letter stating the violation is sent. Now how this is normally done is we have an enforcement officer that he is a retired detective and he knows these types of laws and that thing. He gets the report. Generally Steve is receiving that information, collecting information, and he puts together all of these packets. And then Clay goes out, he does that inspection. If there's no violation, then it doesn't become anything, which does occur. If there is a violation, then they're sent this letter saying that a violation has been found. They have a certain length of time, normally 2 weeks, to try to come into compliance. another inspection is done. So in step 4, a second inspection of the violation is conducted. And number 5, a second letter is sent offering the ability to request mediation with administration. Now the mediation is something that I really wanted to have in here. A lot of people don't like to mediate with the township and that type of thing. And so what I've included here is an option in the letter for them to call for mediation if they want. So they can request it. And therefore we have a time delay between week 3 and week 6 where that mediation needs to be called for and then the mediation needs to occur if the people desire it. If the people don't desire it, of course, they don't have to have mediation. Number 6, if mediation has been requested, mediation takes place. Number 7, if mediation has not resulted in a resolution of the issue, then the administration makes a recommendation for legal action. Number 8, in the case of zoning ordinance violations, administration appeals the action to the Zoning Board of Appeals and issues a summons to the hearing. In the case of a general ordinance violation, the action is appealed to the Board of Trustees, because there are 2 sets of ordinances in the township. There's zoning, which is what most everything is over, but there's an entire other book, which are general ordinances, which don't fall under the purview of the Planning Commission or the Zoning Board of Appeals because they're not covered in zoning. So then that only has the option of going to the Board of Trustees. That's why I wrote it like that. Number 9, the ZBA or Township Board conducts the hearing to decide whether to move forward with the legal action by determining if a violation exists and if due process has been followed. Number 10, legal action is taken in accordance with the findings of the ZBA or Township Board. Now that completes this process here. Of course, if people want to appeal it, they can go to circuit court beyond that. I have additional things in here because that doesn't quite cover everything. 11 is non-compliance with this resolution will not be a legal defense in a court of law. The reason I included that in the resolution part is because we're still maybe working some things out. Is that written complaint recorded at the beginning super important or is it not? As we work those things out, hopefully in the ordinance we can move away from that, but as far as the resolution goes, we're working on it. Number 12, timeframes proposed in this resolution are for guidance purposes and thus are approximations, since I truly am approximating things. When I first got into office, I wanted to look at the enforcement process, and obviously coming into the middle of a bunch of different things. And all I really did was ease up the letters. I made the letters sound a little nicer, a little less aggressive off the front. I added one letter onto the end. And that's all I really did at the beginning so that I could assess how everything was working so we could go about making a change once I was figured out how that process was working currently. Number 13, if compliance is achieved, then enforcement is closed and a thank you letter is issued. Only makes sense. Number 14, partial compliance indicating a willingness to cooperate may allow for a time extension in mediation with a compliance schedule determined by administration. Violation of what has been mediated results in continued action from that step in the process moving forward. And so specifically on that, I gave the indication that I'm for partial compliance and that type of thing, but then a lot of people will string that out over time, which upsets a lot of other people, of course. So it's a difficult thing to negotiate. Number 15, in the case of an emergency situation, administration may seek a temporary restraining order without following this process. I'm not sure to what extent something like that would occur, but if there was some sort of danger, hopefully if we're going to encounter it, we'll encounter it in the next year and we'll know. I wanted that to at least be in there so that I could move faster in that case. But other legal action of shutting something down would have to be outside of the restraining order for the safety reasons. Number 16, in the case of repeat violations for the same type of offense, action may be taken starting at a more advanced step in the process. Otherwise, if you have to go through the same thing and all the neighbors are upset about the exact same process, obviously it makes sense to start further up. And number 17, this resolution applies to new cases started after it is approved by the boards and not pre-existing cases, which of course we had to include because there's no way to just stop everything the township is doing, let things settle out for a few months, and then start operations again. It has to occur as things are moving forward. So in this, I would like to see Dalton Township capable of setting a good example of what due process should be at the township level. And I think this is missing to a large extent in townships. I know that zoning ordinance enforcement is a big thing in all townships. It's a very normal, controversial thing. And I think with something like this, we probably won't get rid of the controversy because we're humans, and therefore controversial because we're trying to essentially do a mass negotiation between people with incompatible ends that they're shooting for through indirect means. That's essentially what the government is. And so I'm hoping this allows for a better application and a better protection of rights for people over time, and that Dalton Township can use that to set an example moving forward for people, and hopefully a good example. So at this time, if there's any questions from the board on it, feel free to take them.
How would you briefly describe what was taking place before?
So what was taking place before was not necessarily a bad process. And it's normal in townships. So it's very similar to the beginning of this. It didn't have a specific step for mediation, but if someone contacted the township, they would talk to them. It was just a little less formalized. And then because it wasn't written like this, then you could have something that could it could skip all of the steps in cases. So for instance, when I got in and talked to the zoning administrator and the enforcement officer, in the case that got me involved with politics a little over 2 years ago, they didn't go through the process. And they both said, they didn't go through the process that would normally be done. We weren't involved, they skipped us. And with implementing something like this, you wouldn't be able to decide to skip those steps, which essentially right now I would be able to do if I wanted to. Obviously I don't.
So there was not a formal letter?
There was a generally accepted process where you would get 2 letters. The final letter would be something saying that you're going to court or a violation has been made, a citation was given out, that type of thing. So there was a letter process that was usually filed.
And is your thinking at this point that the ZBA would review every single one of these, or only by request?
My thinking at this point is that it would be all the enforcements that get to this level, which is relatively few, and hopefully it is few for everyone. And that's one of the ideas with the time frame in here too, or one of the controversies, because people have brought up that this could be a decently long time frame for something to get taken care of. But there wasn't necessarily a short time frame before, especially if the letter process was being followed. If that was being skipped, you could obviously move fast. But if you were following that letter process before, it still ends up relatively long. The thing is that most people, when they receive a letter that they're out of compliance with some sort of ordinance, this type of thing, it's normal for them to comply in a relatively short order. So that takes care of most of that. Most things that would go through this entire decently long process of many steps will hopefully not be too many. And it is recommended by some groups, or I read in the documentation from Michigan State University and Michigan Townships Association, that implementing more intense steps like these causes some things to be resolved before them as well, which is reasonable.
Well, yeah, I think one more opportunity to have it out before court, which is next.
Right. Then it gets very serious, very intense, and of course, I mean, not that it isn't at this point. And obviously, the Zoning Board of Appeals being established is a completely new thing. It's new to all of you. I know you guys have various experience in this realm, but I think a very reasonable step to take, a very reasonable process. Any other questions on anything?
Not at all.
All right. Well, if you ever do have any, and anyone else, of course, too, feel free to contact me. Jeffrey.martin@daltontownship.org. And obviously, you stop into the township. I have meetings a lot of different times, so I don't know if I'll be here exactly if you just stop in, but you can always schedule a meeting with me as well. Feel free to call in too. I will stop the recording, and then I'm going to take off before you guys move on to the next agenda item, so I'm not here when you make decisions.